A very good evening, happy good evening to one and all. Okay, happy good evening to all dear viewers and my dear students. A warm welcome to one and all. So before starting the session, today's power capsule is great people doesn't do great things, but they do small things in a great way. So great people show the results, whereas ordinary people will show the excuses. We all will get doubt how these people are becoming successful, why they are going, why they are achieving the goals, why are not we achieving our goals? What is the reason? It's not great. It's here basically it means that successful people. Every successful, if you see the history of the successful people, they do things they want, they are so passionate about what they want to do. In what way they can get the result. Even a small thing also they do with utmost care. Okay, so what is required here is the passion, the interest towards doing that particular activity for achieving your goal, whatever it might be. Goal may vary from person to person, or it may vary from one stage to other stage in a human life or a human being. So, what I request all your students is everyone can become successful. Have confidence that you can do, and success doesn't come easily. It comes only by your passion and hard work towards achieving it. So I think it's not at all impossible for the students to clear your exam. But you should give instructions to your brain saying that I can do and I can put the result. I can put the effort and I can achieve the result. Okay. So it's all like in what perspective you think, in what perspective you handle that particular your achievement. The achievement process is very, very important. Okay. So with this wonderful note, I'm going to begin the class. Before beginning class, start chese mundama. Yesterday, I got few messages from the students. Let it be motivational or let it be, messages relating to the subject. Few students asked messages related to subject. I have cleared their doubts. And when it comes to things which means like they just wanted, they shared their the result saying that ma'am in the last few attempts low consistent ga, even though I'm putting my effort, I don't know, I'm not able to achieve that mark of 200. My mark, I'm getting the result of 192, 198, 194 or 180 or sometimes even until 198 I will get my mark, but 2 marks I'm going to fail. So the 1 mark, the importance of 1 mark or 2 marks is very much experienced by a CS student. So if you get 199 and 200, the difference is 1 mark. And this 1 mark is very, very important for a CS student. I mean, what is the main mistake I'm doing in the examination? And I'm unable to know. I'm unable to find out what is the main problem drawback. Here, the main problem is you are putting the effort consistently only, but you are not trying to put it in a presentable way. చాలా మంది కష్టపడుతున్నాము, హార్డ్ వర్క్ చేస్తున్నాం మేడం, ఇన్ని గంటలు చేస్తున్నాము, లేకపోతే మేము 15 గంటలు చదువుతున్నాం అంటున్నారే కానీ ఆ 15 గంటలో 12 గంటలో 13 గంటలో హౌ మెనీ అవర్స్ యు ఫిక్స్? ఆర్ వి డూయింగ్ ఇట్ సో కాన్సన్ట్రేటెడ్లీ, సో ఎఫెక్టివ్ గా మనం చేస్తున్నామా? ఆ టైం ని మనం ఎఫెక్టివ్ గా మనం ఎఫర్ట్ లో అంటే మనం అసలు మనం ఏమిటి, మన తప్పు ఏమిటి, మనం ఎలా ప్రిపేర్ అవుతున్నాం, ఏ విధంగా ప్రెజెంట్ చేయాలనుకున్నాం, ఆ 3 కేటగిరీస్ సంబంధించిన ఆస్పెక్ట్స్ అన్ని కూడా మనము ఒకసారి ఇంట్రోస్పెక్ట్ అనలైజ్ చేసుకుంటున్నామా? ఇవన్నీ కూడా మీరు చాలా జాగ్రత్తగా, బికాస్ దిస్ ఇస్ an individual game. I'm telling you, they again and again. Writing a CA exam is not a group game like any cricket. Cricket laga, if one person doesn't bat well, there will be another person to play on behalf of the country. But in CA, we ourselves have to fight for being passed. It's an individual approach. It's not a group effort. where instead of you, there will be somebody to write the examination. Individual, what are your strengths, what are your weaknesses for each and every paper you should analyze. For each and every subject you should think. మనం ఆలోచించాలి ఈ పేపర్ లో మనం ప్రాక్టికల్ ఏరియా స్ట్రెంత్ థియరిటికల్ ఏరియా స్ట్రెంత్ థియరిటికల్ వీక్ అంటే ఆ థియరిటికల్ ఏరియాని మనం ఎలా చదవాలి పాయింట్స్ ని ఏ విధమైన పాయింట్స్ మనం రాస్తే మనకి మార్కులు వస్తాయి. I'm telling you again and again, in theory you should write the basic concept. Without writing basic concept, if you write some other story, they will not give you marks like any other BCom or some in MCom exams. ఎక్కడైనా సరే మన కాన్సెప్ట్ మన దాని యొక్క జిస్ట్ ప్రాపర్ గా రాయగలగాలి. అది మనం ఎక్కడ మనం ల్యాక్ అవుతున్నాం. ఆర్ వి ల్యాకింగ్ ఇన్ రైటింగ్ స్కిల్స్, ఆర్ వి ల్యాకింగ్ ఇన్ ఇంప్లిమెంటేషన్, ఆర్ వి అనేబుల్ టు అటెంప్ట్ 100 మార్క్స్ కంప్లీట్ గా మనం రాయలేకపోతున్నాం. ఆర్ వి అనేబుల్ టు మేనేజ్ టైం. So please, dear students, what I want is everyone sit, take some time for yourself, think where you are lacking, what are your weak areas, and practice and write down those points and try to overcome those weaknesses into strength. Try to overcome those defects into faults into your your major achieving points. Then only you will able to know what mistake you are doing, and see that you don't do that mistake again and again for each and every attempt. Instead of correcting yourself, instead of correcting your approach towards the examination, if you blame the class teacher, if you blame the lectures, or if you blame the institute is not given, it's not at all a correct thing, It's not at all a right approach. We should know what are the main basic problems we are facing in order to come out of it and give our best shot. Once you try this particular aspect and see, the result will be definitely about 200. You can easily score exemptions in your favorite papers. Okay. In all paper you can achieve. The only thing is in what way you should present, because the time is very limited, 3 hours exam for 100 marks. What way I can present, in what way I should understand the concept, in how much time, like in at least 10 minutes before completion of the time I should complete. So the last 10 minutes I should keep checking my paper. And your writing should be legible, very, very important because you are presenting in the form of written form, which should be understandable by the value who is correcting your paper. మీ రైటింగ్ మీ ఒక్కరికి అర్థమైతే సరిపోదమ్మా, మీరు రాసింది 10 మందికి అర్థం కావాలి. ఎవరైతే ఆ పేపర్ ని చదివి కరెక్ట్ చేస్తున్నారో వాళ్ళకి అర్థం అవ్వాలి. అర్థం అయితేనే మీకు మార్కులు వేస్తారు. I will tell you again and again, in law, many students fail because they don't write well in a legible. No beautiful handwriting. Legible handwriting is important here. Presentation is important here. So please focus on these 3 important points. Number 1, you should have conceptual clarity. You should write exactly what they are asking in the question. Number 2, you should have legible handwriting. And number 3, you should present in a proper way. That's either in point wise or in a case law form or in differential table form. You should present in a proper way. And management of time at the same time is very important. See whether these 4 points you are satisfying or not. Judge yourself. You should do your own judgment, and what are you lacking, those aspects try to overcome them. Then only you will achieve your goal easily. And don't get scared that I'm an examination, whether I forget or not is immaterial. మాకు గుర్తుంటుందా మర్చిపోతావా అనేది మీరు ఇప్పుడే ఆలోచిస్తూ కూర్చోవద్దు. ఖచ్చితంగా ఆ మూమెంట్ లో రాసేటప్పుడు పాయింట్లన్నీ గుర్తుకొస్తాయి. Because everybody will have this question. Whoever is preparing for exams, they will think that they will forget. But you will not forget. Your brain is having such a wonderful capacity to store all the information in an effective way. If you give an effective presentation. Okay? Now, what I'm saying is, please don't get first, lose the fear, be confident, and have a right approach. Then definitely this time you will definitely score very good marks in all the papers. Consistent. And one more last important point I want to say, suppose you write an accounts exam and next is your law exam. What you have to do, suppose if you didn't write accounts well, don't continuously think on that particular point of I did not write accounts well, so I am unable to write even law because your time is very minimum. One paper is over, means akkadto aa paper వదిలేసేయండి. Next paper ella రాయాలో focus చేయండి. The impact of one paper should not fall on other paper. Very compartmentalization is very important. Please, these 5 points remember. Number 1, be confident, don't have fear, time management, good handwriting, better presentation, and try not to carry on the impact of one paper on other paper. If you follow all these things, you will do definitely well, and I wish and I have the confidence that my students will do good. Okay, so with this note, I will conclude this particular aspect of motivation for you for today, and we will enter into the topic of share capital. Okay, so now before going into the share capital, let us have a small recap what we have studied in the last class. Okay, last class regarding share capital, we have seen the introduction. What is a share? How many types of shares are there? What is difference between share and a debenture? Okay, so what the definition of share also includes stock. What is difference between a shareholder and a member? Types of equity shares with ordinary voting rights, equity shares with differential voting rights. We have also seen about the types of preference shares. There are 4 types of preference shares. Participating preference share. Next, cumulative preference shares, convertible preference shares, and redeemable preference shares. Okay, and I have already explained. I also explained you the concept of redemption of preference shares. The word redemption is used only for preference share and in case of debentures. The word buyback is used for equity shares. And who only have the voting right in all the general meetings and all the resolutions of the general meeting of the company? Equity shareholders. And preference shareholders, generally they don't have voting rights in the general meeting, but they can vote in matters related to them which are being discussed. But they can attend the meeting. Okay, so what is the process of redemption? What is the maximum life of preference shares? 20 years. However, in case of companies, infrastructure companies issuing shares to the public, for them it is 30 years. So like this, we have seen the introductory part for the share capital. Okay, what are DVRs? What are the provisions for a company before issuing equity shares with differential voting right? What is share certificate? When the company have to issue the share certificate? What is the time limit for issuing the share certificate? And points relating to the issue of duplicate share certificate. Okay, this all we have seen in the last class. And today's class, the agenda for today's class is, and today we are going to discuss regarding calls. Regarding calls and regarding calls in advance. Okay, regarding transfer and transmission of shares, the process of transfer and transmission of shares. What is meant by blank transfer? What is meant by forged transfer? And what is the concept of bonus issue? What is the concept of further issue of equity shares? And also we will discuss the concept of securities premium, which I have mentioned in the last class. Last class I have given a brief discussion about securities premium. I'm going to explain this particular concept. Okay, so hope I understood. So before, let us start the session. Let us see the slides for today. Okay, regarding the share capital. Okay. We have seen the share certificate, and yesterday I have also already told you what is meant by shares in an electronic form. Shares with how we are holding in an electronic form. It's we should open a demat account. This process is called as dematerialization. Okay. Then what is rematerialization? What is rematerialization? If you want to convert this electronic form of shares into physical form, that is called as rematerialization. Okay, these all we have seen. Variation of rights of particular class of shareholders. Okay, so before starting that, already I have mentioned you the concept of securities premium account. This securities premium account is a specific account which is opened by the company when company receives a premium at the time of issue of the share. If a company receives premium amount, what is meant by premium amount? The extra amount that the company gets more than the face value. Suppose the value of the share is 60 rupees. If company gets, because of its goodwill and good demand for their shares in the market, it received 150 rupees. It means that it is receiving extra of 90 rupees. This extra premium amount will be transferred or credited to separate account called as securities premium account. Madam, this premium value, who will fix this premium value? This premium value will be fixed by the board of directors themselves. That's why 150 or 160 or 120, this value will be fixed by the board of directors. Whoever want to purchase our shares at premium value can come and purchase. They will intimate it in the prospectus. Okay, and this premium amount can be received either in form of cash, in form of kind also. That's it. What are the ways of getting this premium amount? Either in form of cash or in form of kind. And all this premium amount, if it is kept in separate bank account, if the premium amount is kept in separate bank account, for what purpose this amount will be used, madam? Endu deni cosmani amount ni use chestaru. Ve purpose cosmani use chestaru ante companies have clearly specified the application of this premium amount under section 52 should be used only for these following cases. It should be applied by the company. That amount cannot be used as the wish of the board of directors. Board of directors వాళ్ళకి ఎలా కావాలంటే ఎలా అమౌంట్ ని యూజ్ చేయడానికి లేదు. వాళ్ళకి నచ్చిన విషయాల కోసం ఆ అమౌంట్ ని యూజ్ చేయడానికి లేదు. They should use only for what purpose they are meant to use, specified by the Companies Act under section 52. Okay, so what purpose they can be used, madam, means here they can use that amount for issue of fully paid bonus shares. Then use fully paid bonus shares. Next, they can use for the purpose of writing of preliminary expenditure. A purpose kosam use writing of preliminary expenses. Next, for the purpose of sometimes shares need discounted value. Madam, generally the concept of discount is not there in company side, but is removed, especially when the company gives shares in form of equity to the employees of the company. Appu discounted price ki istar, appudu a particular premium amount ni use cheyochu. Okay, when the company is redeeming the preference shares, they can use. When the company is redeeming the debentures, they can use. When the company is going for buyback of equity shares, the company can use. Redemption purpose use cheyochu, buyback purpose kuda use cheyochu. Ee purpose, ee specific aspects ke ee premium account ni use cheyali. Vere vetiki kosamu the company should not use this particular premium amount. Okay. So this is all about securities premium account. Now, next important aspect. What is a call? Call is not at all an application money. Okay, application money separate, call money. And call money anedi tarvata vache aspect. What is this call? Means suppose if the company's directors, after allotting shares to the shareholders on the basis of prospectus, then what, as and when required by the company for achieving its objectives, for fulfilling their objective clause, project which is specified in the objective clause of MOA, the board of directors will decide. Who will decide? Board of directors will decide how much amount they should call this time when they were before going for an offer. ఆ షేర్ హోల్డర్స్ ఎవరెవరైతే అప్లికేషన్స్ ఇచ్చి ఎవరెవరికైతే కంపెనీ వాళ్ళు షేర్స్ అలాట్ చేశారో వాళ్ళందరికీ కూడా తర్వాత ఫ్యూచర్ లో దిస్ కాల్ కెన్ బి మేడ్ బై ద బోర్డ్ ఆఫ్ డైరెక్టర్స్ ఎట్ ఎనీ టైమ్ డ్యూరింగ్ ద లైఫ్ ఆఫ్ ది కంపెనీ ఎగ్జిస్టెన్స్ లో ఎప్పుడైనా పిలవచ్చు, లేదా ఎట్ ద టైమ్ ఆఫ్ వైండింగ్ అప్ అయినా పిలవచ్చు. ఓకేనా? whenever they want they can call. Who have to call? Who have right to call? Only board of directors will right to call. Before going for call, they will have a board meeting. They'll pass a resolution and decide at a price of that particular call. And here Companies Act is saying the price of the call should not exceed 1/4 of the nominal value of the share. How much it should not exceed? 1/4 of the nominal value of the share. And మీరు చేసే ఒక కాల్ కి మళ్ళీ నెక్స్ట్ టైం చేసే కాల్ కి మినిమం 1 month గ్యాప్ ఉండాలి. How much time gap should be there between one call and another call? Minimum 1 month call ఉండాలి. అర్థమవుతుందమ్మా? And the value should not exceed 1/4 of the nominal value of the share. So in that way, company will give notice to the shareholders because the company will have in their records, company books of, like register of members, details of shareholders ఉంటాయి కాబట్టి వాళ్ళందరికీ ఇంటిమేట్ చేసి నోటీస్ ఇచ్చి కంపెనీ వాళ్ళు కాల్ మనీని అడుగుతారు. అడిగిన వెంటనే కంపెనీ will also specify the time limit within which the shareholders have to pay. షేర్హోల్డర్స్ ఎంత టైం లోపల కంపెనీకి కాల్ మనీ డిపాజిట్ చేయాలో ఆ పర్టికులర్ టైం లిమిట్ ని కూడా ప్రిస్క్రైబ్ చేస్తారు. Okay, within that particular time, the shareholder have to pay. If the shareholder makes any delay, shareholder delay chesina, late chesina, అటువంటి సందర్భాల్లో the shareholder have to pay interest. ఏం చేయాల్సి వస్తుందమ్మా? Shareholder have to pay interest. Okay, madam, if for suppose even after repeated calls also the shareholder is not responding, not paying the call money, then what is the final option left with the company? First initially what the company will do, the company will do repeated calls, repeated reminders to the shareholders for repeated intimations అనేది ఇస్తుంది. ఇచ్చినప్పుడు వాళ్ళు పే చేయాలి. చేయకపోతే ఫైనల్ ఆప్షన్ ఏంటి? కంపెనీ దగ్గర ఫైనల్ ఆప్షన్ ఏంటి? Forfeiture, cancel away his shares and remove his name from register of members. అతని పేరుని క్యాన్సిల్ చేసేసి అతని రిజిస్టర్ ఆఫ్ మెంబర్స్ నుంచి అతని పేరుని రిమూవ్ చేసేసి ఆ షేర్స్ అన్ని క్యాన్సిల్ చేసేయాలి. దోస్ ఆర్ కాల్డ్ as forfeited shares. ఏమంటాం వాటిని? Forfeited shares. ఓకే, అండ్ ఎవ్రీ ఇయర్ కంపెనీ యాన్యువల్ జనరల్ మీటింగ్ కండక్ట్ చేస్తారు. ఓకే, we'll learn in general meeting chapter details of the annual general meeting. Every year annual general meeting call for చేస్తారు. ఈ యాన్యువల్ జనరల్ మీటింగ్ లో షేర్ హోల్డర్ యొక్క ఓటింగ్ రైట్ ని దేని బట్టి డిసైడ్ చేస్తారంటే, on what basis the shareholder voting right will be decided means on the basis of paid up value of the share on the day of the meeting. Then but nana on the basis of paid up value of the share on the day of the meeting. Enta paid up value దాని ప్రకారం voting rights అనేది ఫిక్స్ చేస్తారు. ఓకే, for suppose షేర్ హోల్డర్ అడ్వాన్స్ కాల్ మనీ కూడా ఇచ్చేసాడు అనుకోండి అమ్మా కంపెనీకి, మరి అడిషనల్ ఓటింగ్ రైట్స్ అడ్వాన్స్ గా ఇచ్చాం కాబట్టి అడిషనల్ ఓటింగ్ రైట్స్ ఏమైనా వస్తాయా మేడం అంటే ఈ అడిషనల్ ఓటింగ్ రైట్స్ వాడికి రావు. అర్థమవుతుందా అమ్మా? ఓకేనా? అండ్ డివిడెండ్ కూడా, ద డివిడెండ్ విల్ ఆల్సో బి డిక్లేర్డ్ ఆర్ పెయిడ్ టు ద షేర్ హోల్డర్స్ ఆఫ్టర్ డిసైడింగ్ ఇన్ AGM based on the paid up value of the share of that particular shareholder. However, కాల్ చేయాలన్నా, కాల్స్ ఇన్ అడ్వాన్స్ తీసుకోవాలన్నా ముందుగా, కాల్స్ ఇన్ అడ్వాన్స్ మీన్స్ వాట్? బిఫోర్ హ్యాండ్ the shareholder wanted to reduce his liability, wanted to complete of his liability and pays all the money to the company. Therefore, company can allot whenever the calls have been made. అలా చేసినప్పుడు అడిషనల్ ఓటింగ్ రైట్స్ వస్తాయా అంటే రావు. మరి అడ్వాన్స్ కాల్ మనీ మళ్ళీ నాకు డబ్బులు అవసరమయ్యాయని షేర్ హోల్డర్ నా అమౌంట్ రిఫండ్ చేసేయమంటే రిఫండ్ చేయరు. The advance call money would not be refunded to the shareholder. If the company goes into winding up, okay, before making all calls, if company goes into winding up, then such advance amount along with interest would be refunded to the shareholders. లేదా కంపెనీ గోయింగ్ కన్సర్న్ లో ఉన్నట్లయితే వాడికి డబ్బులు కావాల్సి వస్తే అడ్వాన్స్ మనీ రిఫండ్ చేయండి అని షేర్ హోల్డర్ అడిగితే రిఫండింగ్ దట్ అడ్వాన్స్ మనీ is not possible at all. Okay, so these are the basic important points which you have to keep in mind regarding calls. Okay, so before entering, so what is call? Who will make these calls? Who will make these calls? The board of directors will make these calls. The value of the call money should not exceed 1/4 nominal value of the share, and the gap between one call and other call should be minimum 1 month. What are calls in advance? And there is respective provisions in the articles of the company. Okay, so if the call money is not paid, what an option left with the board of directors? And in case of advance calls, whether you will get an additional voting right or not are also discussed. These all are important points. And before jumping into the next topic, I have few statements which are asked sometimes in examination. State whether it's true or false. State whether it is correct or incorrect. I want to clarify regarding this one important aspect. If suppose examination law, they ask you to state whether it is correct or incorrect, don't begin a sentence saying that it is correct or incorrect. First write the provision. According to you, why it is correct, why it is wrong, why it is true, why it is false, first state it, first explain in 2 or 3 sentences. First explain the sentence, then give the conclusion. Don't directly write the conclusion saying that it is yes, this statement is true. This statement is correct. Okay, don't directly conclude it. First explain, then conclude. Okay, here I'll give you an example. They're asking, state whether the following are true or false. Partly paid preference shares, can they be redeemed by the company? You told no, madam, company after a certain period of time, the company will redeem the preference shares. Suppose this particular time can be fixed either by the company or they can wait maximum to the period of 20 years. Can they redeem partly paid up shares? Now, I have already mentioned, for the purpose of redemption, only fully paid up shares are redeemed, but not partly paid up shares. According to the provisions of Companies Act, it specifically mentions that only fully paid up shares are redeemed. Partly paid up preference shares are not to be redeemed. And the statement is false. You should then write the statement is false. Okay? Another one. Madam, can shares are issued at premium? You told no. This premium amount can be issued. This premium amount can be collected either in cash or in kind. Is it true, madam? It can be collected other than in cash? Yes, I have already mentioned you in securities premium concept. The premium amount which is collected by the company can be either in cash or in kind. It can be collected other than cash, and the statement is true. Okay, in such way, if they ask you, please write the statement whether it is true or false at the end after giving a brief explanation in 1 or 2 sentences. This is what we have seen, application of premium amount. Okay, except sweat equity shares, company cannot issue. There is a prohibition for issue of shares at discount. Except sweat equity shares, company will not issue shares at discount, at discounted price, and it is void. For suppose by mistake or intentionally, if the company issues shares at discount, the company is liable for penalty, and officer in default is also liable for penalty. Both penalties are mentioned here clearly. Okay, company is liable for minimum of 1 lakh to maximum of 5 lakhs, and officers in default are liable for imprisonment up to 6 months or fine of 1 lakh and maximum 5 lakhs or both. Okay, so whatever case may be, they are liable for the penalty. Okay, this is all the initial part. Now next come to this very, very important concept of sweat equity shares. What is this sweat, madam? Why they are using the word sweat here means the employee or the director of the company. Okay, the employees and the directors of the company who put their effort, who put their hard work for the growth of the company should be rewarded, no? Such employees should be rewarded, no? Okay. For the purpose of rewarding those employees, company will give them few sweat equity shares at a discounted price. At a very less price, they will give those, they will allot them those equity shares to encourage those employees, to encourage those directors who have contributed, who have put their effort, who have put their sweat. Sweat is nothing but a hard work. The meaning of sweat is hard work. For them, either for the applying for their know-how, or they had made some value addition or growth, or they have contributed their intellectual property towards the growth of the company. For those employees, company is rewarding them by issuing the shares, equity shares at a discounted price. Okay, that can be either in case of listed company or in case of unlisted company. Okay, so in such cases, if company want to issue those sweat equity shares, before going for issuing of those sweat equity shares, it is mandatory for the company to pass a special resolution in the general meeting. What the company has to do here? Pass a special resolution in the general meeting. The company should give detailed explanation for whom all employees they are giving this particular sweat equity shares, why they are giving, and they should take the permission of shareholders in the general meeting by passing the special. And the articles of the company should also authorize the company to give sweat equity shares. Okay. And the company initially at the time of incorporation, from the date of incorporation, in the first year of incorporation, they will not issue sweat equity shares. At least 1 year should be completed for the purpose of giving sweat equity shares from the date of incorporation. It is minimum how many years have to be completed? Minimum 1 year have to be completed. Okay, so here, then this once they have decided in the general meeting, once they have decided in the general meeting, they should allot it within a period of 12 months. Within how much time they should allot? They should allot within a period of 12 months. And for whom all sweat equity shares are given, at what price these sweat equity shares are given, all these details, along the details of these employees and directors, should be filled in prescribed form number SH3, and it should be filed to ROC. Once this particular act of issuing is completed, the company should file all the details, should make in a prescribed form of SH3 and file it to ROC. See, whatever act I have already mentioned you in the previous classes also, whatever act the company does, it should specify to ROC finally. Okay, if for these issuing of sweat equity shares, company will not go for any fresh issue. Already issued type of shares only will be already issued. Means what? They have already, some company previously by issuing prospectus, they have issued some 10 lakh shares. In that only 8 lakh are subscribed by the public outside and 2 lakh shares are remaining. Such 2 lakh shares can be issued as form of sweat equity shares to their employees or directors. Therefore, underline this particular point of what type of shares means class of shares which have already been issued. These are very important one, because when you are writing a sweat equity shares, these points are important. Number one, there should be provision in articles. The company should pass a special resolution before issuing these sweat equity shares. Okay, and already issued type issued shares only will be given as sweat equity shares at a discounted price. And after declaration within a period of 12 months, the company have to issue these sweat equity shares. And to whom all they have issued, at what price they have issued, should all the details in prescribed form should be filed to ROC. These all are important basic points which you have to mention in this concept of sweat equity shares. For which type of, you should write introduction, for which type of employees the sweat equity shares are given? The employees who contribute towards the growth of the company, who does some value addition to the company, who gives the know-how to the company, and whose intellectual property will be utilized. For all these categories, if you satisfy any of this category, he would be rewarded. Okay, such employee might be in holding company or in subsidiary of the holding company or in associate of this particular holding company. Okay, or in any of the branch office of the company. If he can work anywhere. There is no mandatory rule that he should work only in the principal company or in a holding company. He can work in any of the combinations of any company which is under the control of the holding company. Such employee or director would be rewarded for his hard work towards the company. Okay, so this is a concept of sweat equity shares over. Next, very important, big elaborate concept of transfer and transmission of securities is ready now. So please everyone be ready with your pen and paper to write a running notes. All points, whatever I am trying to say you in an easier way, please note down. Theoretically, you have the information in your textbook or in the slide which I am showing. But in an interesting way, I will tell you this particular concept. Please note down. Transfer and transmission of securities. It's an elaborate concept. Listen carefully. As I have already told you, why public or investor is interested to invest in the shares or securities of a company? Why is he interested? Because he wants easy liquidity. It means what? Whenever he wants to sell that particular asset, he should get back the money immediately. And he wants a better return. So this is the one of the best option available to the investor or to the public to invest in the shares of the company. So at one point of generally we already seen the definition of public company and private company. The shareholders of public company can transfer the shares whenever they want, freely, without any restrictions. But in case of a private company, the transfer is restricted. The shareholders cannot transfer the shares to outsiders. Within themselves, among their members, the shareholders can transfer. In case of a private company, these restrictions are there. But in case of a public company, no restrictions. The shareholder can freely transfer those shares. Now, madam, for the purpose of this particular transfer, is there any certain legal procedure which have to be followed by the shareholder? Two options are there. That is called, number one is registered transfer. Number two is blank transfer. If the buyer goes for registered transfer, it is a safer option. Registered transfer kelse adi safer option buyer. Endukante adi safe option? Because tanaku tana peruto shares register avutayi and he will get the proof of share certificate in his own name. In his name. But in case of blank transfer, shares are not registered in his name. Shares are registered already in the name of the previous owner. And you don't know when it becomes void. So it is a riskier thing, riskier option. See, if you purchase an asset, for example, if you purchase a land, if you purchase a vehicle, in whose name you want to get it registered? If you want to say it is yours, that asset is yours, it's your hard-earned money, you feel like having the asset in your own name, then you should get it registered in your name. Okay, therefore registration is a safer option for an investor. And the company have to follow prescribed form for this process of registration. The person who is selling the share, the seller is called as transferor here. Here seller is called as who? Transferor. Please remember, please note down. The person to whom the shares are transferred is called as a transferee. Is called as a transferee. The buyer. What the Companies Act says is, either the transferor or the transferee, any one of them can approach the company, okay, take the respective registration form, that is form number SH4, take that particular respective registration form, fill your details and attach a stamp according to Stamp Act, pay the prescribed fees and submit it to the company along with the share certificate. ఎందుకు ఇవన్నీ చేయాలి? For the purpose of registering the shares in the name of buyer. Okay, I'll tell you point in step by step. I'll tell you the points. Okay, so the registration of transfer is a voluntary act of either transferor or transfer. It's a safer option available to the buyer. Point number one. What they have to do in the first step, either the transferor, listen carefully, or the transferee can take the prescribed instrument in prescribed form SH4 for the purpose of registration, fill their details, the name, their occupation, their address, how many shares they have taken, all the details they have to mention, and they should attach a stamp to that particular instrument and pay prescribed fees for it. They have to attach a stamp and pay the stamp duty, mandatory. Stamp duty generally will be paid by the transferor only. If transferee pays, he can collect it from the transferor. They'll attach the copy or they'll attach the share certificate to it, and they will also attach the letter of allotment to that particular instrument of transfer, and they have to submit within 60 days from the date of execution. Means from the date of paying the stamp duty within 60, otherwise the instrument would become void. Time limit is also important here. Within 60 days, they have to submit it to the company. Now for that, there is separate department in the company under the head of any director who will look after the registration of transfer. What they will do, they will receive this particular application. They will receive this particular instrument for transfer of shares and getting registered in name of transferring. Application chusina tarvata, if the shares are fully paid up, shares are transfer avutunayi anukondamma, ఈ ఫుల్లీ పేడ్ ట్రాన్స్ఫర్ ఆల్రెడీ అంత షేర్ ప్రైస్ అంతా పే చేసేసాడు. చేసిన తర్వాతే అమ్మాలనుకుంటున్నాడు. అలాంటప్పుడు అసలు ఎటువంటి ప్రాబ్లము లేదు. కంపెనీ వాళ్ళు హ్యాపీగా రిజిస్టర్ చేసేస్తారు ట్రాన్స్ఫరీ పేరుతో, బయ్యర్ పేరుతో. ఇఫ్ ద షేర్స్ ఆర్ ఫుల్లీ పేడ్ without any doubt, the company will directly register the shares in name of buyer. If all the formalities like payment of stamp duty and filling the details are perfectly done, then they will register in name of the buyer. However, very important point, keep it as a star mark. In case of partly paid up shares, in case of partly paid up shares, అంటే ఏమిటి? సపోజ్ ట్రాన్స్ఫర్ సెల్లర్ ఎవరైతే షేర్స్ అమ్మాలనుకుంటున్నాడో వాడు ఫుల్ గా వాల్యూ ఆఫ్ ది షేర్ మొత్తం ఇంకా పే చేయలే, ఇంకా కొంత అమౌంట్ పే చేయాల్సి ఉంది. బికాస్ కంపెనీ డిడ్ నాట్ మేక్ కాల్స్ యెట్, దే హ్యావ్ టు పే them in future. In such cases, the company will not register the transfer without getting permission from transfer. అప్పుడు కంపెనీ ఏం చేస్తుందంటే ట్రాన్స్ఫరీకి నోటీస్ పంపిస్తారు. మిస్టర్ బయ్యర్, డూ యూ నో దట్ యు ఆర్ పర్చేసింగ్ పార్ట్లీ పేడ్ అప్ షేర్స్ ఆఫ్ ది కంపెనీ? వాట్ దే విల్ ఆస్క్, ఏమడుగుతారు నోటీస్ లో? మిస్టర్ బయ్యర్, డూ యూ నో దట్ యు ఆర్ పర్చేసింగ్ పార్ట్లీ పేడ్ అప్ షేర్స్ ఆఫ్ ది కంపెనీ? Are you ready to purchase them? Are you ready to discharge the liability for unpaid value of the share? Okay, if you accept, if you give your permission without any objection within the prescribed time, then we will register the shares in your name. Who gives this notice to whom? The board of directors of the company gives this notice to the share buyer. That is nothing but transferring. The transferee will see the notice. If the transferee knows that, if he is clear that he is purchasing partly paid up shares, yes, directors, I know the fact, I am ready to discharge the unpaid value, and please register these partly paid up shares in my name. If he gives his permission to the directors without any objection, then the directors will register the partly paid up shares in the name of buyer. Understood? Okay. If he gives any objection, then what they will do? Then and there they will stop the registration process. Okay. Therefore, all problem comes, all these verifications comes only in case of partly paid up shares. In case of fully paid up shares, happily, without any doubt, without any explanation from the buyer, the company will register the shares in name of buyer. Once the company is happy to receive no objection letter from that particular buyer, the company will register the name, will register the shares in name of the buyer, and on the share certificate, either on the face of the share certificate or on back of the share certificate, they will enter the shares are transferred to so and so Mr. X, the buyer, and the company under the common seal and under the signature of the directors, they should send the share certificate within how much time limit we have discussed in the last class? In case of registration of transfer of shares, the share certificate should be submitted to the transfer within how much time? Within 1 month from the date of application for registration of transfer. అంటే ఎంత టైం లోపల షేర్ సర్టిఫికేట్ ని పంపించాలండి ట్రాన్స్ఫరీకి? ఏ రోజైతే వాళ్ళు ఇన్స్ట్రుమెంట్ ఆఫ్ ట్రాన్స్ఫర్ ని కంపెనీకి ఇస్తారో అక్కడి నుంచి నెల రోజుల లోపల ప్రాసెస్ అంతా కంప్లీట్ చేసి ట్రాన్స్ఫర్ కంటే బయ్యర్ కి కంపెనీ వాళ్ళు షేర్ సర్టిఫికేట్ బయ్యర్ పేరుతో ట్రాన్స్ఫర్ చేయాలి. అర్థమవుతుందా అమ్మా? ఓకేనా? సో దీస్ ఆర్ ద వెరీ ఇంపార్టెంట్. ఒకసారి షేర్ సర్టిఫికేట్ అంతా ప్రిపేర్ చేసిన తర్వాత కంపెనీ రిజిస్టర్ ఆఫ్ మెంబర్స్ ఉంటుంది కదా, బుక్ ఉంటుంది కదా, అక్కడ ఏం చేస్తారంటే పాత షేర్ హోల్డర్ పేరు, the name of old shareholder, the transferor, they will strike off the name there and they will write the new name of the buyer. Transferee పేరు రాస్తారు. సో అలా రిజిస్టర్ ఆఫ్ మెంబర్స్ లో ట్రాన్స్ఫరీ పేరు రాయడం వల్ల the transferee becomes the member of the company. Transferee will be called as a member of the company and he will have right to vote in the meeting if it is a equity share. What is the benefit which the transferee gets? He will have the right to vote and will be called as a member. From then onwards, he can receive or enjoy the dividends on those shares which are announced by the company. What he can enjoy? Dividends he can enjoy. These are the 5 important steps for the purpose of registration. See, point number 1. Either the transferor or the transferee should make an application in a respective instrument on a prescribed form number SH4, filling all their details and signing it. Okay, transferor, transferee, their details, their profession, their occupation, their addresses, everything they have to mention. And along with it, they have to attach a stamp and pay the stamp duty. Okay, once all these formalities have been completed, within 60 days, they should file this copy along with the share certificate or the allotment letter. Once the company receives this particular application, company will look into the matter whether it is fully paid up share or partly paid up shares. If fully paid up shares, it will not ask for any advice or any approval from the transferee. It will directly register the shares in name of transfer. However, in case of partly paid up shares, the board of directors will send a notice to the transferee requesting him to give his explanations regarding whether he is satisfied with the shares are partly paid up, whether he is ready to pay the balance unpaid call amount on the shares. If there is any objections, they'll ask him to state. And if he replies that he doesn't have any objection, then they will register the name of that particular transferee or the buyer. Okay, and automatically on the share certificate, they will specify the shares are being transferred to so and so transferee, and immediately they will, in the register of members also, they will change the old shareholder name and they'll enter with this particular transferee's name. With that, the transferee becomes a member of the company and he will have right to vote in the company, and he will have the benefit of enjoying the dividends on those shares. In this way, this particular ended transaction is. Okay, it's a procedure for registration of transfer. Here, very, very important, like practical part area type of questions, I will explain the concept, then I will tell you, discuss those case laws. Suppose, madam, here suppose the transferees, madam, the buyer should be only a natural person, or buyer can be an artificial person also, or buyer can be an institution also. Yes, sir. Buyer can be anybody. Buyer can be either natural person or buyer can be either an artificial person. What is artificial person is? Buyer can be any company or a body corporate or a partnership firm or an HUF or an AOP or a trust. The person who is purchasing the shares can be either a body corporate or a company or a trust or a partnership firm or an AOP or an HUF. You will ask one more, madam, can a buyer be a minor? Can minor purchase the shares in a secondary market? Madam, I am 17 years old. I have pocket money which is gifted to me on my birthday. And I want to purchase, I want to save that money in form of shares. So can I purchase shares from the open market? What the Companies Act says, and one of my uncle wishes to transfer his shares, can I purchase from him? Madam, you can ask that doubt also. What the Companies Act says is, in case of minor, listen carefully, in case of minor, only fully paid up shares they can transfer. Minor can become a holder in case of fully paid up shares only, not in partly paid up shares. If he receives any partly paid up shares, they are void ab initio. The transaction is not at all valid. Understood? Now your doubt is clear? Madam, suppose I am a minor. I applied on the basis of prospectus. I applied to a company that I want 100 shares. I have so much pocket money. Can I purchase shares? Can a company allot shares to me? Here, what the Companies Act says is, company should not allot the shares to a minor. Company should not come into contract with a minor. By mistake, if company allots shares to minor, it should immediately cancel that particular allotment and refund back all the money to the minor. Very, very important examination practical case area. Please understand these two important varied aspects relating to a minor. In case of transfer of fully paid shares, yes, minor can receive fully paid up shares. But in case of allotment on the basis of prospectus from a company, no, minor should not be allotted, even though how much money here, minor should not be allotted shares from a company. By mistake, if company allots also, what immediate steps the company have to take? The company should immediately cancel the transaction and the company should refund back all the money given by the minor. Understood? These are very, very two important concepts relating to a minor. Okay, now you already mentioned, no, ma'am. Now the share, the buyers can be body corporate, the buyer can be a company, the buyer can be a partnership firm. Whose name they will write in register of members, madam, in such cases? Okay, in case when shares are allotted to a company or a body corporate, as we all know, company is separate from its members, and the share is nothing but an asset to the company. They will record it in the name of company itself, not in the name of directors or founders or subscribers. Okay, in whose name the shares are recorded? Shares are recorded in name of company itself. However, before registering the name of the company which have undergone this registration process will look into MOA and AOA. They will check the MOA and AOA of the other company, the transferee company. They will see which director who is responsible for this particular registration process. If everything is fine, the company will record the name of the company in their books as a transferee or as a buyer. Understood? This is in case of a body corporate or a company. But when it comes to the case of partnership firm, partners and firm are same. Therefore, if in case of a partnership firm, if shares are transferred to the partnership firm, the shares are registered in name of partners. Important examination bit. When the shares are transferred to a partnership firm, in whose name they are registered? In name of a partners, not in the name of firm. Except in case of Section 8 company shares. If Section 8 company shares are transferred to a partnership firm, then the shares are registered in name of firm. Please note down this difference. Students, please make it MR. Please write in your notebook. If the shares are transferred to a partnership firm, the shares are registered in name of partners. However, in case of Section 8 companies, we have seen at the time initial chapters, kinds of companies or types of companies, Section 8 non-profit company. In that particular case, the shares are to be registered in name of firm. The difference. Okay. Now next. In case of an AOP, if shares are transferred to an association of persons, if shares are transferred to a AOP, then shares should be registered in name of office bearers. In whose name they have to register? In the name of office bearers. Okay. If shares are transferred to a HUF, then the shares have to be registered in name of Karta. Please remember all these points. In case of an HUF, shares are to be registered in name of Karta. If the shares are transferring to a trust which is registered under the Societies Act Trust, the shares are being transferred to a trust which is registered. Okay, the shares have to be transferred in name of trust itself. If it is an unregistered trust, then shares are registered in name of trustees. If the shares are transferred to a trust which is registered, then shares are registered in name of trust itself. Otherwise, if the shares are transferred to an unregistered trust, then shares are transferred in name of transferee. Okay, now understood. These all are bits which they asked in your exam. If a transferee is a company, shares are recorded in name of a company. If the transferee is an HUF, shares are recorded in name of Karta. If a transferee is an AOP, shares are recorded in name of office bearers. The transferee is a firm, shares are recorded in name of partnership firm. Except in case of Section 8 company, shares are registered in name of firm itself only. Okay. If the shares are transferred to a registered trust, then the shares are entered with the name of trust itself in their books. If it's an unregistered trust, shares are entered on the name of trustees. These are very, very important points which you have to keep. If the shares are transferred to a minor, only when they are fully paid up, minor's name they will enter. Partly paid up, no, this is refused. This is not accepted. Okay, this is all about transfer. Then what? And once the shares are transferred, within how much time the company have to give the share certificate? Already I have told you in the last class share certificate. The share certificate should be given within 1 month from the receipt of the instrument from the transferor or transfer. In case of incorporation, 2 months. In case of allotment, it is 2 months. However, in case of debentures, it is 6 months, the time limit. Okay. Now, if company fails to follow the prescribed procedure for registration of transfer, if company could not submit the share certificate within prescribed time, if company could not register the transfer, even though after all necessary documents submitted by the transferor or transferee, if company and its officers fail to do so, fail to follow the prescribed procedure for registration of transfer, then company and officers are liable for penalty. What will happen? Company and its officers would be liable for penalty. Okay, this is all about registration of transfer. Before going for transfer or transmission of shares, I have few cases here. Let me explain it. Okay, see, please everybody look on to the material which has been shown. Here, see, we the transferee. Okay, not this case, this case. Okay, so let us discuss first 3 and 4. Then later on, we'll go for that particular forged transfer. X had applied for 1,000 shares in a company. No allotment of shares was made by the company. Initially, on the basis of prospectus, X asked for 1,000 shares in a company. The company did not allot them. Okay, he left off. Later on. Okay, what the company have to do, the allotment once if it is made, it should be made within a reasonable period of time and it should communicate. It didn't communicate. After few months, after some time, or after few months, without any application, X still didn't ask the company to again allot the shares. Without any application, what did the company do? You know, company have few partly paid up shares, 1,000 partly paid up shares. అంటే కంపెనీ దగ్గర ఏవో కొంతమంది షేర్ హోల్డర్స్ పే చేయకపోతే కొన్ని నెలల తర్వాత పార్టీ పేడ్ గా మిగిలిపోయినాయి 1,000 షేర్స్. అప్పుడు ఏం చేశారంటే కంపెనీ వితౌట్ ఎనీ నోటీస్ ఫ్రమ్ ది ఎక్స్ దే టోల్డ్ ద ఎక్స్ దట్ దే ఇంటిమేటెడ్ అంటే బిఫోర్ అలాటింగ్ షేర్స్ దే ఇంటిమేటెడ్ ఎక్స్ దట్ we are allotting this party paid up shares to you and we are entering the name in the register of members of the company. Now what this X have to do? After getting this information from the company, what does X have to do? If we really wish to become, ఎందుకంటే he is getting partly paid up shares, he would be responsible to pay the balance call money కదా. ఏం చేయాలి? ఇమీడియట్ గా కావాలి అనుకుంటే ఓకే అని చెప్పిన తర్వాత తీసుకున్న తర్వాత he should be ready to pay the balance call money. వద్దు నాకు ఈ షేర్స్ వద్దు అని అనుకున్నప్పుడు ఏం చేయాలి? ఇమీడియట్ గా ఇఫ్ ఇట్ డజంట్ వాంట్ he should intimate to the company immediately and ask the company to take back the shares. He doesn't want those partly paid up shares. But he did not respond at all. And remaining silence is also said to be acceptance. He remained silent. He nicely took those partly paid up shares. And company later on made the final call. Final call చేసింది. But he refused to pay the call money. Because he don't have money and I don't want to pay. Can he do so? ఒకసారి షేర్స్ అలాట్ చేసిన తర్వాత షేర్స్ తీసుకున్న తర్వాత కావాలంటే అలాట్మెంట్ యాక్సెప్ట్ చేయాలి, లేదు అంటే he should immediately revoke his acceptance. Without doing, he remained silent. And when company is asking him final money, he refused to pay. Is it acceptable? Is X refusal valid? Can he escape from the liability? Companies Act is asking. Can he escape from liability? No, he cannot escape from liability. He is liable to pay the balance final call money to the company because initially he did not reject the allotment. Initially he remained silent. He accepted the allotment. Therefore, he is liable to pay the call money to the company. This is important. Okay, next one. RSP Limited allotted 500 fully paid up shares of 100 rupees each to ZM minors. In the minus cases coming. In the above case, the member is the particular X is becoming a member by yes couple. Okay, so he is treated as a member. He cannot reject his membership and he will be liable to pay. Now, in this case, next fourth case, RSP Limited allotted 500 fully paid shares of 100 each to ZA minor. Based on the replication. I told you, can a company allot shares to a minor? No. Company should not allot. By mistake, company allotted shares to a minor and entered their name in the register of members. What the company have to do? Immediately knowing the fact that he is a minor, immediately the company should remove his name from the register of members and take back the shares and give back his money, refund back his money. But what happened here? See? Later on, the company came to know this fact. The company cancelled the allotment and struck off his name from register of members. These all company did so nicely, so correctly. And also forfeited his entire share money. It means that, you know what, if the company did, company cancelled his name from register of members, company cancelled the shares. At the same time, the company cancelled his money also. What the act is saying, in case of a minor, you should refund back the money also. Here, nicely, they're enjoying, the company is enjoying the money. The directors are enjoying the money which they have taken from a minor. Is it valid? No, minor had filed with the help of a guardian, filed a case in the court of law against the company. Now, what the Companies Act is asking, decide whether the minor will get relief from the court or not. Now, what you have to say, according to the provisions of Companies Act, a company cannot allot shares to minor. If by mistake it allotted shares to minor, they have to cancel those shares, remove his name from register of members and refund back the money. If company fails to refund back the money to the minor, company is liable for penalty. Here, yes, so the Z would be given relief by the court. Would be given relief, Z would be given relief by the court. Okay, so this is an important aspect. In this particular way, the questions would be asked in the examination. So I'm mentioning this particular case law. Please, everyone, go through these and try to answer them. Okay, before going to case law 1 and 2, let me explain few important concepts. I told you about blank transfer. No, there are two types of transfer, two options available to a transferring. One is registered transfer, other one is blank transfer. Madam, what is meant by blank transfer? In case of blank transfer, what will happen is, first initial ga X ane vyakti పేరుతో shares ఉంటాయి. This X ane transferor want to sell his shares to some Mr. P. What the appudu P antadu, no, I don't want to get this registration process done because within 1 or 2 months even I want to sell the shares. Every time when you want to get it registered, we have to pay some stamp duty to the company. Why extra cost for us? So andukani X ane vyakti tho emantadante, please give me the share certificate. Take this particular application form. Don't pay any stamp duty. Please give me the application form with your details filled. X, who is the initial transferor, who is the initial seller, will fill in the details as a seller and sign the particular transfer form and hand over it to the next buyer P. Incomplete instrument he will transfer along with the share certificate. Now, what P will do? He will find some other similar person like him in the market. Okay, from P, it is transferred to Q. Now, Q also takes this incomplete instrument along with share certificate, give the amount of value of share to P. Here, is any of this transaction between X and P and P and S are, intimated to our company? Evana company intimate avutunaya? No, all here is happening is blank transfer. The transfer is not getting registered. And finally, when it reaches to the hands of Q, the buyer, Q ane vaadu inga amma anukovatle shares in the future. He want to keep the shares with him for longer period of time. What he can do, he can take that particular instrument form and he should make it complete by filling the details of transfer there. So as a Q, as a buyer, what he will do? He will fill in all his details, pay the stamp duty and get shares registered in his name. అప్పుడు షేర్స్ ఎవరి పేరుతో రిజిస్టర్ అవుతాయి? క్యూ. మరి మధ్యలో ఎక్స్ కి పి కి జరిగిన ట్రాన్స్ఫర్ ఏమవుతుంది మేడం? బ్లాంక్ ట్రాన్స్ఫర్ అయిపోతుంది. సో ఒరిజినల్ సెల్లర్ will be the transferor and the final buyer who want to keep the shares with himself and who pays the stamp duty to the company get the shares registered in his name. అప్పుడు షేర్ సర్టిఫికేట్ ఇన్స్ట్రుమెంట్ ఆఫ్ ట్రాన్స్ఫర్ కంపెనీ వాళ్ళకి సబ్మిట్ చేస్తే ఆ షేర్ సర్టిఫికేట్ విల్ బి రిసీవ్డ్ ఇన్ నేమ్ ఆఫ్ క్యూ. నౌ ఇన్ బిట్వీన్ దట్ ఇంటర్మీడియట్ పార్టీ పి అనే వ్యక్తి ఉన్నాడు కదమ్మా, ఆ పి అనే వ్యక్తి ఉంటాడు ఆ పిక్చర్ లో. కెన్ హి బి సీన్ ఇన్ ద పిక్చర్? నో. The transactions between X and P are totally blank. Nobody knows. But they enjoyed this particular sale. Understood? చాలా సార్లు ల్యాండ్ రిజిస్ట్రేషన్స్ లో కూడా ఇలా జరుగుతూ ఉంటాయి. కానీ అక్కడ ఆ రిజిస్ట్రేషన్ రిస్కీ రిజిస్ట్రేషన్, because P is taking a risk of getting the share certificate not in his name. This is an example for a blank transfer. Next one, forged transfer. Madam, what is this forged? What is meant by forgery? Remember one thing, any transaction involving forgery. Forgery means what? Altering someone's signature, writing someone's signature. Any transaction involving forgery or void ab initio in Indian Contract Act, as well as in Negotiable Instrument Act, as well as in Companies Act also. Understood? Any transactions involving forgery are void ab initio. Okay. Now, suppose, madam, for example, if a transferor X, Mr. Transferor X, the share certificate is in the name of X itself. Okay. He went to a share broker's place. He forgot his share certificate at his place. What this share broker did, you know? He took the share certificate. He got an application form from the company. He forged the signature of this initial transferor X, and he sold the shares to innocent buyer, Mr. Y. Who did all these things? The share broker with whom the share certificate is there. What he have to do? He have to give back the share certificate to X, no? Because X does not want to sell the shares immediately. X came to X approached you to know the market price of the share, but he forgot the share certificate with you. As a genuine fellow, as a true fellow, what you should do? You should give back that particular share certificate to X, no? You nicely misutilize this opportunity and you sold the shares, and some fellow Mr. Y is waiting for the shares to purchase the shares of the company. Nicely sold the shares to premium value to Mr. Y. Here, as a transferor, X have to sign that particular instrument. No, X did not sign. Share broker knows the signature of X, so he forged the signature. Share broker signed on behalf of X. Nicely, they applied to a company. Company doesn't know. Company cannot trace out, no, because it is as much a similar matching to the signature of X. Some company nicely registered the shares in name of innocent buyer, Mr. Y. And later on, this particular fraud have been known to the X, the original buyer, original seller, the true owner of the shares. Later on, X came to know this particular fact that his share certificate is gone and someone has taken and forged the transfer had taken place and it is transferred in the name of Y. He made an application to the company giving all these details and information. Then what the act will do, you know, what the Companies Act remedy given, no? The Companies Act here, it is giving protection to the original transferor, because the transaction here involved is forgery and it is void ab initio. Therefore, what the Companies Act does in this particular case is, Companies Act will say, company, please cancel away the share certificate given to Mr. Y, who is an innocent buyer who doesn't know about this forgery. Pay back his money and send back the share certificate to the true owner by writing back his name on it. Send back it to the true owner. And you find out who is the real culprit, who is the person involved forgery, and claim damages from them. Now understood? What is the remedy available to the true owner? He can get back his share certificate in his name. What is the remedy available for the innocent buyer there? He can claim compensation or money from the company. Now, what is the remedy available for the company? Company can file a case against the person who have done this particular act of forgery. Understood? This is very important case in case of forgery. It is given here. See, we the transferee who acquired 300 equity shares of ABC Limited from S, the transferor, but the signature of yes and a transferor on the transfer deed is forged. B, after getting the shares registered by the company in his name, he sold subsequently 250 shares to Mr. X, who is an innocent buyer. Explain what are the rights available to yes, V, X and against the company. In case of true owner, what he can do? He can get back the shares in his share certificate in his name. Here S is the true owner, he can claim back. And the innocent buyers are there, no? Innocent buyer, Mr. X is there, no? Finally, innocent buyer X, he can claim damages from the company. So in this way, in case of a forged transfer, okay, in case of a forged transfer, the true owner can claim the compensation, can get back the share certificate. The innocent buyer can claim the compensation and company can file a case against the person involving the forgery. Okay, so this is all about your transfer of share, the procedure for transfer of shares. We have seen what is transfer of shares, what is meant by blank transfer, and what is said to be a forged transfer also. In this, you can ask me some doubts like, Madam, first suppose during this registration process of transfer, you told 1 month it will take to give the share certificate to the shareholder. If during this time, if suppose any general meeting is held, who will attend the general meeting? Who have to vote in the general meeting? Either transferor have to attend or transferee will attend the general meeting. Here it is clearly said that if transferee had paid entire money to transferor, but still transferor's name only will be there in the register of members, no? Transferor only will attend the meeting. But voting can be done on the wish of the transferee. If transferee still he did not pay the entire money sale value, transferor will vote according to his own wish. For suppose if in between during this period, if company have given some dividends or bonus, that is divided among the transferor and transferee based on their agreement. They will draft an agreement saying that until this date, all the bonus is yours. From this date onwards, bonus or dividends are mine. So according to their agreement, pre-entered agreement, they will decide. Okay. So these are the points which you have to keep in mind regarding the share, regarding the transfer of shares. Okay. First, suppose if the shareholder is having 100 shares of a company, madam, for the purpose of transfer, he can transfer all the entire 100 shares. Or if you want, he can transfer just 60 shares. For entire 100 shares, there is only one share certificate, no, madam. Then in that particular instances, what he will get here, what the Companies Act says is, for the 100 shares, if there is only one share certificate, if you have to sell the shares and if you have to get it registered, the share certificate will be given to the company. And for balance shares of 40 shares, he would get a separate receipt from the company that is called as balance. You would get another receipt from the company for the balance share that is called as balance ticket. Okay, for the balance shares. But you have to surrender the share certificate to the company. These are the important points relating to the transfer of shares. So we have seen what is transfer of shares, what is called as blank transfer, what is forged transfer. Okay, now I'll explain you the process of transmission of shares. Transmission means here, transmission is nothing but which takes place by operation of law. Okay, at the time of death of the shareholder or insolvency of the shareholder. What is called as transmission? Transmission is nothing but which takes place by operation of law automatically in the case of death of the shareholder or insolvency of a shareholder. At the time of death or insolvency, the shares are automatically transferred to their legal heirs, to their nominees. To whom the shares are transferred? To their legal heirs, to their nominees. Madam, in that particular process, does a nominee or legal hire does to get registered with the company or pay the stamp duty? All these formalities are necessary? No, not at all. Automatically, the shares will be given to this particular the nominees and the legal heirs of the shareholder. However, madam, okay, fine. They are the shareholder, the nominees and legal heirs of the shareholder will enjoy the benefit of taking the shares in their name. Suppose if the shares are partly paid. Madam, if the shares are partly paid, who have to pay the balance call money? The estate of the deceased. What it says? The estate of the deceased. The estate of the deceased. Deceased means what? The deceased here means the shareholder who is expired, who is dead. Deceased means what? He is not getting any disease here. ఓకే, ఎవరైతే చనిపోయారో అతని ఆస్తి నుంచి ఆ పర్టికులర్ బ్యాలెన్స్ కాల్ మనీని పే చేయాలి అంటున్నారు. ఓకేనా? ఇన్ కేస్ ఆఫ్ పార్ట్లీ పేడ్ అప్ షేర్స్ అయితే, పార్ట్లీ పేడ్ అప్ కాకపోయింది అనుకోండి, ద నామినీ అండ్ లీగల్ హైర్ విల్ ఎంజాయ్ దోస్ షేర్స్. There are two options available to those legal heirs or to the nominees of that particular company. Two options available. What are those two options? Means the legal heir or the nominee can continue as a shareholder or a member of the company by getting his name entered in the register of members. Second option is he can sell in the open market. If you want the money, if you want to enjoy the cash, he can sell it in the open market. Two options available to the nominee. What are those two options? Number one, if you want to become member of the company, he should intimate the company and you get the shares registered in his name. Second option, otherwise he can sell it in the open market. Madam, if you want to get the shares, if you want to become the member of the company, what is the process? He should intimate it to the company along with some proof of death certificate and identity card. The legal hire chooses to become member of a company. What he have to do? Here, no need any instrument of transfer or payment of stamp duty is not necessary in case of transmission of shares. Remember, in case of transmission of shares, payment of stamp duty and filing an instrument of transfer deed are not at all necessary. What he have to do in prescribed form is intimate to the company saying that he want to continue as a member. He is willing to continue as a member. And he should submit the death certificate of his shareholder. And he have to submit his identity proof in what way he is belonging to in what way he is called as the legal heir of that particular shareholder who is deceased, who have died. Okay, once he submit the proof and all other formalities have been completed, the shares are registered in name of the legal heir or a nominee. And his name will be entered in the register of members. This is one option available to the legal heir. The other option available to the legal heir is he can sell away the shares in the open market. Okay, so this option is available in case of transmission of shares. Here shares are freely transferred from the shareholder to the legal heir without any consideration or without any money because of operation of law. Okay, now here one more point. Everyone, a very important examination. Madam, every shareholder of a company can appoint a nominee. For suppose I am having shares in a company. Okay, I have a share certificate. Can I make an application form? Can I nominate somebody in my absence? Can take this? I can nominate my husband, my children, anybody I can nominate. So here in the Companies Act is saying a nominee can be a minor also. Nominee can be a minor, nominee can be a major. Suppose if joint shareholders are holding shares. Joint shareholders means myself and my husband are holding shares in a company. Both of us can nominate together only one minor share. Yes. Joint shareholders can nominate a single share. Or if you are having two children, I can nominate one share, my husband can nominate another share. Okay, so in this way, you have to be clear with three important points. Number one, nominees can be a minor. Yes, nominee can be a minor. In case of joint shareholders, both can nominate a single minor or single person or single nominee. If he is a minor, major means major. Or else joint shareholders can separately nominate their nominees. Okay, these are the options available. So in this particular aspect, there is asking a case law over there. Mrs. and Mr. Premchand are joint shareholders in XYZ Limited. They wish to appoint their minor son Ajay as a nominee. Is it possible? Now, what I have told you, you have to write it as a provision. According to the provisions of Companies Act, yes, the joint shareholders can appoint their son as a nominee. Joint shareholders can appoint a single nominee. And the nominee can also be a minor. Okay. Is such nomination subsequent to purchase of shares feasible? What's the meaning of feasible? Feasible ante sadhyam avutunda, kudurutunda, jarugutunda అని అంటున్నారు. Feasibility ante will it happen? Is it possible? Yes, it is possible. If so, can the proposed nominee be a minor? Nominee minor అయి ఉండొచ్చా? Minor అయి ఉండొచ్చు, major అయి ఉండొచ్చు. Can joint shareholders appoint single nominee? Yes, joint shareholder can appoint single. All these are important aspects relating to nomination. So this is the entire concept of transfer and transmission of shares. I hope everyone noted down all the important points regarding transfer and transmission of shares. What is transfer of shares? Okay, what is transmission of shares? What is a grant transfer? What is a forged transfer? And I also explained you the concept of nomination. Now, next very, very important theoretical question. This particular part is asked as a theoretical question. That the procedure, they will ask you, I'll tell you once again, the procedure for transfer, explain the procedure for transfer of registration can be asked you as a theoretical question. Or they will ask you, right, please explain the difference between transfer and transmission of shares. Or they may ask you in a practical format. Okay, whichever way possible. Whichever way it is convenient for the ICA, they'll ask. But you should be ready in whatever mode they ask. You should be able to write and explain them. Now, this particular part of refusal for registration of transfer and appeal against the refusal. Under section 58, this is asked in your examination theoretical part. I will tell you what is it exactly. I'll explain. Transfer iddaru kalisi, both of them together had applied to the company for registration of transfer, hoping that the shares would get registered in his name. But company refused the registration. There are so many reasons for refusal. I will explain you. What are the reasons? What would be the reasons for refusal for registration of transfer? For the company, either public company or private company, may refuse the registration process if it thinks that instrument form is inaccurate and instrument form is sarigga file cheyakapoyina. Prescribed form is a proper stamping when if there is no proper stamp and payment of stamp duty is also not made properly. Okay, if they think so, they may refuse. If they come to know, they will refuse. And if they think that shares being transferred are partly paid and transfer is a minor, they will stop the transfer process. Okay, the company come to know that the transfer is a minor and shares are partly paid up, they will stop. Or else, if the transferor have taken some money as a debt, lien or a loan on those shares, and he have to still pay the money to the company, he didn't pay. In such case, until the payment is made, shares would not be transferred. They would restrict the transfer. However, in case of private company, if the company comes to know that shares are being transferred to some other third party outside who is not member or relative of the company, in such case, private company can stop that particular registration. These are n number of reasons which are available for the company for refusing the transfer process. Okay, if company refuses the transfer process, he should intimate it within a period of 30 days from the date on which it have received the instrument of transfer. ఎప్పుడైతే అది రిఫ్యూజ్ చేయాలనుకుంటుందో అది కనీసం ఇన్స్ట్రుమెంట్ ఆఫ్ ట్రాన్స్ఫర్ ఫామ్ వచ్చి నా 30 రోజుల లోపల నోటీస్ ఇవ్వాలి. ట్రాన్స్ఫర్ కానీ ట్రాన్స్ఫరీ కానీ ఫలానా కారణం వల్ల దిస్ ఇస్ ద రీజన్ వై వి ఆర్ రిఫ్యూజింగ్ ద రిజిస్ట్రేషన్ ఆఫ్ ట్రాన్స్ఫర్ అని మెన్షన్ చేయాలి. రీజన్స్ కూడా స్పెసిఫై చేయాలి. మేము ఎందుకు రిఫ్యూజ్ చేస్తున్నాం అన్న విషయాన్ని చెప్పాలి. ఓకే, దెన్ ఆఫ్టర్వర్డ్స్ the transfer or transferee, appudu vaalaki if they are dissatisfied, if they are not satisfied with the reasons provided by the company, if they think that company is creating some false reasons, then what they can do within prescribed time, this either the transferor or the transferee can make an appeal against the tribunal against the company. అప్పుడు ట్రాన్స్ఫర్ కానీ అగ్రీవ్డ్ పర్సన్, ట్రాన్స్ఫర్ కానీ ట్రాన్స్ఫరీ కానీ అగ్రీవ్డ్ పర్సన్ అంటారమ్మా. ఎందుకంటే అతను నష్టపోతున్నాడు, ఎందుకంటే అతని పేరుతో షేర్స్ ట్రాన్స్ఫర్ అవ్వట్లేదు. ఏవైతే రీజన్స్ కంపెనీ వాళ్ళు చెప్పారో అవి జెన్యూన్ కాదు, అవి కరెక్ట్ కాదు అని అనుకుంటాడు, he can with the proper proof he can submit, he can file a case against the company in tribunal. ఎంత టైం లోపల సబ్మిట్ చేయాలి మేడం కేసు? In case if a notice is given, notice of refusal is given by the company specifying the reasons. In case of a public company, either within 30 periods from the date of receipt of notice, the transferor or transferee can file a case against the company in the tribunal. Other private company, either 60 days from the date of receipt of notice. Suppose as a company one notice ఇవ్వలేదు, ఆ registration కూడా చేయట్లేదు. Once a registration is not happening and notice of refusal is also not being given by the company. The transferor and transferee are waiting for the company's reply. They are not knowing why the transfer is not being registered. వాళ్ళకి అర్థం కావట్లేదు. అలా they are waiting almost 2 months over. In case of a public company, within a period of 60 days from the date of filing an instrument of transfer to the company, transfer transmission to the company, వాళ్ళకి తెలియదు 2 months వెయిట్ చేశారని వాళ్ళ ఓపిక నశిస్తుంది. వాళ్ళు ఏం చేయొచ్చు ఇప్పుడు? They can make within 60 days appeal to the tribunal. In the same way, in case of private company also, if the company is not giving them notice of refusal, company is not telling the reason for refusal, they are waiting for registration. Company is not giving and doing any registration. In such case, within a period of 90 days from the date on which the instrument of transfer is submitted to the company, they can file against the company in the tribunal. Now, what the tribunal will do? Tribunal will look into the matter. Tribunal will decide the case. If tribunal thinks that company's refusal is invalid, then immediately company will pass the orders in favor of transferor or transferee and ask the company to complete the registration process within next 10 days. Okay, and if the company and its officer fail to comply to the order of the tribunal, they are liable for the penalty. Whatever order passed by the tribunal is final. Okay, if the tribunal passes the order in favor of transferor or transferee, it is mandatory responsibility of the company and its directors to fulfill that particular obligation or fulfill that particular order within a period of next 10 days. If they fail to do so, they are liable for penalty. It is given here. Understood? This is in case of refusal for registration of transfer. Madam, in case of rectification of register of members, say for example, I will tell you, I told you whenever the transfer formalities are completed, registration is completed, immediately the company should rectify its register of members, strike out the name of transferor, and I write the name of registered transferee's name. Okay, if the company, even though after completing registration process and even after submitting the shares appeal to the transferee, still the company did not rectify its register of members. Still the company did not rectify it. The transfer is waiting when the company will call me for general meeting, when the company will make alterations, it is not doing at all. In such cases, the transfer at any time, whenever to his notice, whenever it comes to his notice, at any time he can make an appeal to tribunal. First he will ask the company, please rectify, there is some spelling mistake in my name. You did not correct my name. You are still writing the transferor's name itself. Please rectify. If the transferee is asking even after repeated reminders also, if the company is not responding, then in such cases, company can, the particular aggrieved person, either the transferor or the transferee, can make an application to the tribunal. ఏంటంటే అమ్మా ఇక్కడ రిజిస్టర్ ఆఫ్ మెంబర్స్ లో షేర్ హోల్డర్ పేరు తప్పుగా రాసిన, షేర్ హోల్డర్ పేరు కరెక్ట్ గా రాయకపోయినా, షేర్ హోల్డర్ కెన్ రిక్వెస్ట్ ద కంపెనీ టు ఆల్టర్ టు కరెక్ట్ ద రిజిస్టర్ ఆఫ్ మెంబర్స్. Even after repeated requests also, if company failed to do so, shareholder ఏం చేయొచ్చు అప్పుడు? We can make an application to the tribunal. అదే ట్రాన్స్ఫర్ అయినప్పుడు కూడా ట్రాన్స్ఫరీ తన పేరు కరెక్ట్ గా రాయకపోయినా, లేకపోతే తన పేరు రిజిస్టర్ ఆఫ్ మెంబర్స్ లో లేకపోయినా, he can request the company first initially. If even though after his repeated request, if company failed to do so, what he can do finally? He will go and appeal to the tribunal. Then tribunal will look into the matter, and tribunal, if he thinks that it is company is doing some wrong, then it will request the company to rectify its register of members within 10 days. If company failed to do so, the company would be liable. Understood? Both cases. In case of normal shareholder and in case of a transfer. These are very, very important aspects relating to rectification of register of members. If company failed to comply the order of the tribunal, company and its officers are liable for penalty. So first one is what is transfer. Next one is what is transmission. What is difference between transfer and transmission? What is called as blank transfer? What is called as forged transfer? And we have also seen the procedure. Why? What are the reasons why the companies will refuse this registration process? What are the reasons why the company will refuse? If company refused, then what is an option? What are the options available to the aggrieved person, that is say the transfer or transferring? They can go and appeal against the company to the tribunal. Okay, so with this, we have completed today's concept of share capital. Okay, so we will see the tomorrow's concept. The remaining tomorrow's concept regarding the buyback of shares, and the rest of the things we will see in tomorrow's session. Okay, I hope today we understood all these concepts of sweat equity and concept of transfer and transmission, securities premium, calls and calls in advance, all which we have discussed are clearly explained to you. Okay, here a few students are asking, Madam, can a government company issue sweat equity shares? Yes, sir. Any company, they didn't specify this particular company, but company, even within a period of 1 year from the date of incorporation, following the formalities, they have to issue the sweat equity shares. Okay, so any company, in order to encourage its employees, in order to encourage its directors, they will issue sweat equity shares. I hope it is clear for everyone today's discussion. I hope it is clear. If you have still more doubts, you can message me to the number I have given. Okay, thank you so much for for your patience listening, and I hope everyone noted what all important points I have discussed in today's class. And see you all tomorrow. Have a happy evening. See you tomorrow, same place. Thank you so much. Take care. Bye bye.